The long-standing High Court authority on patentable subject matter in Australia is the case of National Research Development Corporation and Commissioner of Patents. The National Research Development Corporation, here referred to as NRDC, discovered a new method to apply known chemicals to the soil so as to kill weeds but not crops. The chemicals were known to science but were never used in the process of eradicating weeds. NRDC, for this reason, applied for a patent for their new discovered process. However, the Commissioner of Patents rejected the application on the grounds that it was not a manner of manufacture under Section 6 of the Statute of Monopolies, for the following reasons. 1. The invention was neither a new saleable product nor a new process for producing a saleable product. 2. The invention involved an agricultural process, which could not be a manner of manufacture. 3. The invention was merely a new use for an existing product. The Commissioner argued that the definition of invention is restricted to vendible products and the processes for their production, and excludes all agricultural and horticultural products. However, NRDC argued that the process could be considered manner of manufacture, subject to the definition in the Patents Act 1990 and grant of privilege under Section 6 of the Statute of Monopolies if the result is economically useful. The issue for the court was to determine if this new process of weed killing constituted a manner of manufacture and could therefore be considered a patentable invention. The court had to consider whether it is enough that a process produces a useful result, or whether it is necessary that some physical thing is either brought into existence or so affected as the better to serve man's purpose. The court considered at great length what was meant by manner of manufacture and found that the definition was not a literal definition but found in common law, evolving over time. The High Court confirmed that for an invention to be patentable, it needs to be either a product or a process. Well, when is a process considered a manner of manufacture? The case of GEC's application provided a test for just that. A process satisfies the test if A. It results in the production of some vendible product, B. Improves or restores to its former condition a vendible product, C. Has the effect of preserving from deterioration some vendible product to which it is applied. However, the court defined vendible product broadly, and for this reason other elements were used to determine whether a process is a vendible product. The court considered that for a process to fall within the limits of patentability, the process must be one that offers economic advantages. After considering these factors, the High Court allowed the appeal and awarded a patent to NRDC, as the new process could be considered a manner of manufacture, on the basis the process was only found because of NRDC's extensive research, of which held economic value to them and provided a vendible product to the community. This case is important as it provides clarity to the concept of manner of manufacture.